So thank you very much for making to this event this afternoon in the middle of all the rains that are going outside, and I know how bad the traffic was, but all of you are here before even you know we started here. So I think wonderful, and thank you so much for coming over. We have a number of people on the phone as well as on the webinar. So welcome everybody from every part of the world. And my name is Nishith Desai, and I really welcome you all to today's interaction. Uh, every time the Gift City comes for discussion, I vividly recall walking with then the Chief Minister of Gujarat, Narendra Modi, on the boat quay in Singapore, and that's where this idea was born. And it was notified in 2011. It's almost 2019, will be 2020. So it's almost now how many years? I would say 12, 13 years. But at the end of the day in India, there hai lekin andher nahi, hopefully. And there are always constant challenges that we encounter. But in the middle of that, this has fructified, and I would give singular credit to Dipesh Bhai. He's the chief of Gift City, and I'm so excited that he has found time to be with us this afternoon. And welcome, Dipesh Bhai. He has worked so hard. There are moments of frustration, and how to. It's almost 10 years. How long you've been?
11 years.
11 years. So you can see the patience with which he has worked, and I am amazed the way in which he has continuously worked on this whole project. So I think it's become a long way. I think in next 3 to 4 years it will move on fast forward. So I think then really the gift in a full bloom manner we'll be able to see, and I think it might also be an answer to number of questions that are we are confronted with in the normal setting of our country, and at least because this is carved out as a foreign territory, a lot of issues may at least there will be an answer to solve. How much we solve is a thing to be seen, but I'm sure that this gift answers quite a few you know answers, so that there are some ambiguities, some other kind of stuff. There's more certainty and stuff like that. I think generally our experience with special economic zones have been reasonably well overall, I would say. And whole software industry grew out of SEZs and many other industries as well. So I think same way for the financial services sector, gift is really a gift, because to make exception on number of things within the domestic area is sometimes difficult, but special concession that is given to this kind of enclaves is it becomes more like a laboratory. So you confine your experiments to a particular area, and even if you go wrong, sometimes you have an ability to correct, or it is confined to a particular geography in which it is being said. And lately, I think as far as alternate funds are concerned and other kinds of funds are concerned, maybe for even FPI, which we'll discuss a little bit later, GIFT hopefully will provide more answers, and it will be easier for government also to make exception in that area. So I think it's a very important place to now look at. It has become an integral part of our economic liberalization process. So we experiment that. If succeeds, then it can be taken to the domestic tariff area as well. And with those words, let me, ask Dipesh Bhai. First of all, as I mentioned, he is the chief. He has everything in his control, may I, right? And so he can respond to my question. And how has the first of all, let me ask you, how is the response coming up to for the setting up of AIF in GIFT? Because a lot of talks are going on, and what's the reality on the ground? Uh, you know, um, Especially since the circular of November 28, 18, and other development that have taken place. So can you tell us a little bit how people are taking up to this GIFT at this point in time.
Sure. Thank you, Nishith Bhai. I think it's always been pleasure to be at this place. I've been visiting this office for last many years now, and I always get fascinated when I see the books of how to open funds in Mauritius, how to open fund in Singapore, and I always keep asking Nishith Bhai, when would you have a one booklet on how to open a fund in GIFT? I'm sure soon his office would have booklets for people to figure out how to open office in the fund in the GIFT city. But let me, I think, give a background that although the company got incorporated in 2007-8, the GIFT City, the land got allotted to the project in 2011, and virtually the groundwork started in 2012. However, the operating guidelines or the business regulations were not issued, and it got issued only in April 2015 when the Honorable Finance Minister was in GIFT City and they announced the regulatory regime for GIFT to be operationalized. And that time the missing piece was the tax. So tax came in 2016. So from that perspective, between 2016 to 19, we consider we are 3 year in our journey, because after that, once the business regulations were out and the tax were clarified in 2016, then someone thought to open an office and then get started. So we got in last 3 years now close to 165 companies in the zone, and I think the daily volume in terms of the transactions in business has been growing quite well. But you gave a lot of credit to me, but I think the real people who have found this is our chairman, Mr. Sudhin Mankat. He has been the driving force behind the entire Gift City project since 2008 when the company was formed 2007. And current our managing director, Mr. Tapan Ray, who's the ex corporate affairs secretary, he's been now in charge of the whole project, and he has given us a great clarity in terms of how to take this project forward. So I think we've been fortunate with the right type of leaders. We've been given the right type of platform by the government of India now to make it comparable and competitive to other financial centers. Otherwise, till that we were talking, but we were not comparable when it came to Mauritius or Singapore. And in terms of this year's budget, I think two, three very important changes came out. One was the government of India announcing a 10-year tax holiday out of 15 years. That is a big one. I really consider out of all the announcement, the 15 years, any 10-year tax holiday is a good starter for anyone who is thinking of a long-term investment. Otherwise, we were getting inquiries and they were saying after 5 years, what happens? I'm better off to go
Right.
back to Mauritius or Singapore. But this being in place now, that is behind us, that you have a 10-year window available with you. And I think on the fund side, the alternate investment fund, while obviously GIFT is in the news in terms of some of the announcement in the budget, but I think the work started in October 2018 when the work with the SEBI went in terms of what could be a structure of an AIF. And I must not take away the credit of people sitting on this dais. I think Nishith Bhai, his team, and in particularly Tushar, who is here from PwC. We worked towards on operating guidelines, discussed with the SEBI, and now between 2018 November and now, which is to July 2019, we are close to 10 funds which have already made an application to give to set up. One fund has gone ahead and got the first level of approval from the SEZ authorities, and his application with the SEBI to be approved anytime from now. So we will get the first fund operational in that zone. And there are series of other funds which have found these structures better. So I think the interest is tremendous because it's a clear visible advantage. It's not on paper. It's not a PPT. It's you come. The city is operational. 9,000 people are working there, and the infrastructure is, even if it's raining or it's not raining, you will always reach on time in your offices in Gift City. So the infrastructure is fabulous in terms of the operations, and we are seeing continuous growth in terms of people coming in that zone. So I think it's an advantage for India to have this type of setup and allow people to do offshore transactions onshore, which we have exported outside, but we are able to bring them back in India with the jobs also coming back to India.
Yeah, thank you so much. I think let me also turn to one of the very important persons, Tushar Sachdeva, his partner at PwC. A lot of experience, extremely well known in the fund industry. And maybe you can tell us some practical considerations for the setting of a fund in the Gift City.
Thank you, Nishith Bhai, and of course, we and NDA work together on many fund structures together, whether it is on the gift side and also outside of the gift side. And we had an opportunity, of course, to work with Devesh Bhai in terms of working on this operational guidelines and also representing before the government in the changes which are required to make this come to life, if I may so. So the idea, of course, of the government is to kind of manage in India initiative as you have Make in India. The idea is to how can you bring the offshore funds which are currently sitting out of say Mauritius or Singapore or somewhere else. Why should they be operating out of other jurisdiction and not? Why should they not operate out of GIFT? So that's the whole idea. So the intent of GIFT is mainly to raise money from a non-resident investor. It is not meant for raising money from a domestic investor. So I just want to make that first clear. Except, of course, in a situation we are working also with RBI and SEBI to kind of call out a product where you can say if the resident investors want to invest in offshore products, can you create a product for a resident investor to create a product out of GIFT? But coming to specifics of tax, so once the operational guidelines were out, we had to kind of work on the other regulations in terms of taxation and, for example, given that the whole gift IFSC guidelines or the law itself is based out of under the SEZ law. So therefore, there are certain requirements under the SEZ law, like net foreign exchange requirements and all, that we had to kind of get clarity on with the Commerce Ministry. So, in essence, in GIFT, based on operation guidelines, what is required is that you need to have a manager. Now, manager could be in form of a branch of an existing asset management company that you have in India, if you're already operating an AIF in India, or you can set up a separate company, or you can set up a LLP. So you need a manager. Then you need a fund. So fund would be a licensed fund under SEBI AIF regulations based on operation guidelines, which are similar as such if you compare to the domestic guidelines. When you look at from a tax perspective, the way the approach of the government has been that from a FEMA perspective, GIFT has been treated as a non-resident jurisdiction. So any entity which is set up in GIFT is treated as a non-resident. However, when it comes to taxes, under tax law, it is still treated as resident. So they have adopted an approach of giving concession rather than to make a kind of blended, the blanket kind of treating it as a non-resident. So therefore, you look at each of the entity, whether you're looking at a manager or you're looking at a fund, and what's the implication. The important aspect is from a very broad perspective, as such, the fund and the investors are neutral. So the idea is not to give any benefit because you don't want to create any arbitrage in terms of people coming from one jurisdiction to another jurisdiction from a WTO promises perspective also. So don't want to create arbitrage on an investor. However, when it comes to fund management, given that you're doing that activity, you get the full tax benefit. So the intent is to give the 10-year now, of course, earlier it was 5 plus 5. In fact, that was also represented by us in terms of to the government to see that extend that by 10-year holiday. So that you get as a fund manager. You don't pay tax for 10 years. Your MAT is reduced to 9% in gift if you have a MAT liability. If you have a company structure or a LLP structure, you do not pay any GST. There is no distribution tax. So there are significant benefit when it comes to any corporate structure that you adopt. You don't need to adopt a LLP structure. Even a corporate structure, you will not even pay the distribution tax. So that's the benefit, significant benefit for the manager. So you don't need to structure your structure as carry structures and all that. You can take a straight performance fee, and you will not pay any income tax. And also there is no GST paid. So that's a significant benefit from a manager perspective. From the fund perspective, if you look at AIF 1 and 2, those are anyway pass-through structures under the law, and therefore the tax is paid by the investors. One of the significant asks we had is that there is a requirement from a compliance perspective for the investors because they have to file return if it is a pass-through structure. So there is already acceptance. The representation has already been made, and there is already acceptance. There would not be a requirement to file return. That notification is still not out, but it will soon be out. Hopefully, in the next 1 month, we should see a notification which will give exemption for filing of the tax return. While on the PAN card, the government's view is that the PAN is identification of investor, so we don't want to give a relief. But as it's just identification number and it should be easy to comply. But from compliance, actual compliance from filing of return, there may not be a requirement. So I think one thing I wanted to touch upon was this whole venture capital fund industry, right? So if you look at today, a lot of venture capitalists they are not setting out domestic AI, and the reason for that is because many of these venture funds are looking at offshore investment, and there is a SEBI restriction that you cannot invest more than 25% of your corpus in the offshore company. And many of these companies, venture companies, are like situated in the US and all, so you can't bind your hand with that 25% restriction. So therefore, if you look at now the gift structure, it is a very interesting structure because SEBI has given exemption for that 25% circular. So you can almost invest 100% of your corpus in a foreign company if you want to. And recently there was a circular clarification issued by CBDT, which also in fact we had represented, sir, where the CBDT has clarified that if there is a non-resident investor in the AIF, and if it is deriving income from a non-resident investment, then that non-resident investor will not be taxable. So, in essence, therefore, if you're a venture capital fund where you're raising money from a non-resident, that venture capital fund is investing in, say, a US company. So, if there's a capital gain tax arising out of that, that will not be taxed in India in hands of that non-resident. It's a very significant. While that benefit has been given to all AIF because they couldn't distinguish between a domestic AIF and offshore AIF, but in fact, the representation was made by GIFT to give this clarification, because otherwise there are sourcing rule in India because the structure is still in India. So somebody might tax you on the basis of receipt of income in India. Somebody might tax you on the basis of the source of income is in India. And FPI 3, I think maybe I can have Rajesh or somebody to touch on the FPI structures when it comes to.
So what Tushar Bhai is saying is that in the US we are familiar with the concept called disregarded entities. What you call pass through, they call it disregarded. That means you disregard. So if US investor has invested in the fund and funded invested in other geography, it is as if it is directly invested because this is a disregarded entity. It's a pass through, but that's how it is. So it's a very important clarification that you provided to her, and I really appreciate doing so. So there are many other interesting structures and experiments one can do in GIFT. I think therefore I called it a lab, in some ways for all of us, where you can safely play with some of the rules and still get the benefit that you expected out of it. That brings me to Rishi Sancheti. Of course, all of you know Rishi. I'm the founder and the head of the organization. He's the brain. So he leads a funds transformation practice. And so, if I may ask you, what are the different opportunities and for whose benefit this AIFs, set up particularly in IFSC, that's International Financial Services Center or GIFT City, you know, what you can do and what particularly in the context of, let's say, trust,
Right.
what would you
Right.
like to say, the trust in GIFT City?
Sure. See, I think as far as alternative investment funds set up in India are concerned, whether it is Category 1 or Category 2 AF, which invest in private equity or VC or unlisted opportunities by and large, a good attraction or a real attraction for setting up AIFs in India by and large has been that if the AIF is managed and controlled by resident owned and controlled vehicles, the entire color of money is seen as a domestic investment, irrespective if the entire commitments have been raised from overseas investors. This is a significant item which makes the AIF in India a lot more attractive than foreign investments directly into India traditionally have been. This is the area where onshore AIFs versus a gift AIF have a pivotal difference. This brings to the fore the SEBI operating guidelines that sort of came out late last year, which clarified that if a gift-based AIF is investing in Indian unlisted opportunities, it would be under the FDI program. So clearly, if we are looking at a gift-based structures, we are talking about FDI compliant investments. Instruments also have certain restrictions. The sectors and so on and so forth you're looking at also you have to be sort of more cognizant of the FDI restrictions that we're talking about. Then what would make a gift based AIF attractive? The answer also lies squarely on how the manager is sort of set up. If the team is by and large in India, then for them to sort of attract overseas investors, you end up setting up Mauritius, Singapore, or Cayman based feeder vehicles, which is more acceptable to the wider global LP audience, and so on and so forth. So then, could they perhaps consider a pooling vehicle in GIFT, where global investors can come in, and they could then invest in India, and also if they have a sort of a subsidiary or some amount of presence in GIFT, given the tax holiday that Tushar spoke about, where there is a tax holiday for 10 out of 15 years, and also that there is no GST, it not only safeguards the management fee you are earning, but also in case there was an adverse view taken on carried interest, if it was recharacterized as business income, then again it is going to get hopefully covered under the tax holiday we are talking about. So that clearly is the two buckets of difference. From a GP perspective, obviously the GIFT opens up a lot of tax efficiencies, but from an investment program perspective, if you're looking at a non-FDI environment to sort of operate, an onshore AIF perhaps still may make sense. The second aspect we can look at is a category 3 AIF. They are the other format of the AIF. Category 1, 2, like I said, by and large unlisted. Category 3 on the liquid products, again in India. There, a good distinction factor for a category 3 AIF vis-a-vis FPIs is the amount of NRI participation you can sort of have. As an FPI, there has been so much of back and forth on the regulatory aspect that are NRIs allowed as a class, how much of NRI participation can you take in, single NRI concentration limits, and so on and so forth. If the platform is ultimately designed as an AIF and all you have overseas is a feeder vehicle, then some of these restrictions just don't apply. An AIF can literally go live even with one single LP, an investor out there, even if that investor happens to be an NRI. So that is a trade-off perhaps one could have thought of if you were setting up an FPI versus a category 3 AIF. Obviously, there are a lot of nuances around the category 3 AIF taxation. We still till date do not have a efficient tax code in the tax act hardwired, unlike the category 1 and 2 formats where you have a lot of certainty. Now, if we move the structure to, let's say, a gift based platform, then clearly the manager related advantages on performance fee, management fee, and so on and so forth is already out there. But the moment you invest in Indian opportunities, you still have to sort of come through the FPI investment program. Now, while one could take a view that, okay, because the investors have been pooled under the AI format, perhaps that gift based platform can have some amount of NRI participation, and clearly government's own thinking that can we merge the portfolio investment scheme for NRIs into the broader FPI format. They'll also add a lot of clarity that can a gift based structure be an efficient pooling for NRIs. But the bigger point here is that when an AIF setup in GIFT is investing in India under the FPI program, you are relying on the very stable tax code already grandfathered in the tax act for FPIs. All taxes are to be paid as an FPI investor, and accordingly everything is seen as capital gains. What it means is that while we play, back and forth on the category 3 onshore AIFs, that should the fund pay tax or should the unit holders pay tax, mutual funds, as you are aware, is exempt, unit holders pay tax. In cat 3 AIFs, you can take a position that, okay, let the AIF be sort of pay tax and the investors sort of get a tax pass through. Whereas in case you come from a gift structure, an FPI obviously pays tax, and so that discretion in your hands that should the unit holders of a gift-based investors sort of pay tax, that shouldn't arise. So there's a lot of tax certainty. Having said that, a gift-based structure may not work for all strategies because you're investing under the FPI program. It means that you're hit both by 10% of the corpus rule of an AIF versus also a 10% of an Indian company because you're investing under the FPI program. So the AIF restriction was meant to preserve the investors so that they get diversified. The FPI restriction was to ensure that the retail audience, where a foreign portfolio investor is coming in, is not sort of seeing the volatility of one investor. So both the whammy sort of hit. So which is where we understand that there is a lot more clarity which is anticipated, especially that can a gift-based AIF only be bound by FPI conditions and not the AIF conditions. Which brings us to the more pivotal question then, where does a gift based AIF today, let's say we are speaking on 27th of July or 28th of July, or maybe first of this current week, where do we now stand? So here we are seeing a juxtaposition where a gift based AIF perhaps either invest directly if you are happy with FDI compliances or you are happy with the FPI AIF restrictions, or you could come in through a onshore AIF based sort of a master fund with some amount of direct investment so that you can defend why you should be entitled to tax benefits. Similarly, are global investors comfortable coming directly into GIFT? Answer perhaps is no, still, because investors want a lot of certainty on the tax and regulatory aspects. Given that some of the issues around GIFT is still in fluxation, what happens is you may still end up setting up a feeder vehicle for global investors. Again, the same jurisdictions came in Singapore and so on and so forth, and maybe then bring them to the GIFT based structure. So I think both on the strategy, style of investments as well as pooling, there is still some more work in the make where we are.
Yeah, I think that's very interesting. And I think let's move on to some of the tax issues. As I said, Rishi is my left brain, his brain count, and I'll have my right brain, Rajesh. He leads the international tax team and particularly, you know, uh, the free zones. So maybe can you just tell a little bit about how would AIFs be treated in AIFs from tax perspective? Could they enjoy tax holidays available to units in the SEZs? Or could pass-through apply? We discuss a bit about it. You may elaborate. And what are the recent tax amendments for AIFs in GIFT?
Sure. Thanks, Nishith. I think let's just break it down into two or three different parts, right? When we are talking about taxation of a fund, on one side you're looking at how the fund itself is going to be taxed, and on the second side you're going to see as to how the manager is going to be taxed. And one of the advantages which gift offers is more on the manager side as compared to the actual fund side. And the second question, and which is the question which always keeps coming up, is that how does a AIF in gift compare with possibly a domestic AIF versus possibly a Mauritius or a Singapore structure? Because that's really the comparable which people tend to do, to see from a choice standpoint, saying that should I just do a offshore fund, or do I do a master feeder structure where I have a feeder entity in Mauritius or Singapore with a master AIF in India, or the third choice being that I will just have a AIF in India where all the investors come in. So that's really the comparables which people sort of look at in terms of saying that am I better off or am I worse off in terms of setting up a entity in a gift versus possibly domestically or possibly as a from a offshore funds, setting up a pure offshore fund standpoint. Now when you look at how, because ultimately a AIF which is set up in gift is also you still have the same pass through taxation which is applicable if you had set it up in the domestic in the domestic category, where you have a pass through as far as category 1 and category 2 AIF is concerned. And for category 3, obviously if you set it up as a domestic AIF, category 3 we are still living with the ambiguity in the when you set up a domestic AIF as to whether the income you're going to get the pass through or you're not going to get a pass through, and everything will be taxed as business income in the hands of the category 3 AIF. When you're setting up something in gift, you're still going to enjoy the same pass through for a category 1 or a category 2. So you're no different from setting up domestically versus setting up in the gift AIF. As far as category 3 is concerned, and this is one of the points which Richie was making, is that you get a bit more certainty on category 3 as compared to setting up a category 3 in the domestic tariff area. Because in category 3 AIF, when you're setting it up in Gift City, you're effectively treated on par because you're also getting a FPI registration. So your tax consequence also follows the FPI taxation which is there. So which is how it sort of stacks up if you start comparing a AIF situated in India in the domestic tariff area versus a AIF set up in Gift. The second part is that okay, if I'm setting up a AIF in Gift, how do I compare against a Singapore or a Mauritius, right? Am I better off just setting up a pure play offshore fund, or do I need to or should I just consider a Gift AIF? Now, obviously, with all the treaty changes which have happened, whether on Mauritius or on Singapore, to a large extent, you're not really getting any kind of arbitrage in terms of setting up a fund in a Singapore or a Mauritius, except possibly on the debt side where you're still getting some degree of benefit, but you're still getting the same benefit by setting it up in a gift AIF, because what you end up doing is effectively ensuring that the pass through still works. So you're still getting the advantages of, let's say, setting it up in the offshore jurisdiction or doing the offshore fund. I think the one advantage which probably the gift AIF may have over, let's say, setting up in the domestic area or setting up in Singapore or Mauritius, is that, as Richie said, one of the structures which you can always work with is to do a master feeder where you have a gift AIF with a feeder entity sitting actually in India. So the complications that we all live with, which is in the sense that how do I actually end up having, let's say, my manager entity outside India? Because all of us have struggled through it, right? In the past, where I have domestic Indian managers, how do they set up their offshore structures in order to ensure that they can act as manager to a fund set up in Singapore or to a fund set up in Mauritius? All of it sort of goes away with a gift structure, where insofar as if you do a master feeder structure where I have the feeder entity in gift and all the LPs come in directly, you effectively have the look through available for category 1 and 2, and at the same time, if you want to take the advantage for downstream investment or from a FOCC perspective, that will effectively come into the master AIF sitting in India. But net when you sit back, at least from a fund standpoint, right, you're not worse off than setting up a pure play domestic AIF versus setting up a offshore fund structure, where a gift AIF still gives you all the same pass through treatment which would have otherwise been there, with additional clarity on category 3, and at the same time your complexity around structuring for the manager coming down. The second part of it is in respect of the manager taxation, which is where I think there is a lot of what you would call incentives which are actually provided. I think some of the incentives that Richie spoke about it, is that one, you potentially end up enjoying the, especially post the budget amendments which have come in, you end up enjoying a tax exemption or a tax holiday for 10 out of 15 years. That's one big advantage in some terms of setting up the manager entity there. The second thing which Tushar was pointing out, potentially you can structure carry as just a performance fee, so that that is also treated as business income and you still go into the tax holiday. The third aspect around it is around the GST exemption. I think anyone who's been in the last 2 years, whenever you're setting up funds in India, I think most of the discussion gets into, okay, how am I structuring in respect of the management fee? Is there a risk of GST? Is there a risk of GST on carry? So we've gone through a lot of it, right? What the gift setting up a manager there gives you the flexibility or gives you the incentive is that the whole GST conundrum sort of goes away, and that's a huge incentive just looking at the sheer cost, right? Because GST in any event would have been sunk cost, otherwise you're looking at a 18% tax. The fourth aspect, and this is again one of the budget changes which has come in, is in respect of dividends which are actually given by a unit in IFSC, where there is an exemption which is also provided in respect of the dividends declared, which effectively means that you're coming in through a as close to a tax neutrality position as far as a manager is concerned as you can potentially get to, right? You can obviously set up multiple different structures, LLP, owning a manager in gift, set up as a company. So you have multiple different scenarios to ensure that you have a smooth extraction even in respect of profits which are sitting in the manager entity. And I think that's where I think probably from a manager standpoint, the gift has given in or provided similar, if not better, new tax neutrality as compared to, over the last 10 years we've all set up our structures with a manager entity sitting in Mauritius or Singapore, have a back end cost plus arrangement with the Indian sub advisor, with all of us living saying that okay, we believe that the cost plus will be respected, we believe that there will not be a permanent establishment, but we've gone through a lot of hoops around it. I think what the gift structure gives you is that the whole taxation around manager becomes a lot more simpler, a lot more cleaner, and a lot more tax neutral without getting into the whole litigation risk that all of us were living at with offshore structures. I think that's really the key when I think about, and as I said, whenever you look at an AIF being set up in gift, you look at fund taxation and you look at the manager taxation. Fund taxation, you're not worse off as compared to setting up in offshore or setting up in domestic AIF. Manager, you're probably a lot better off. So let me just pause there. Tushar, feel free to add. in terms of any other
No, I think
tax laws.
you well articulated the fact that compared to the domestic AIF structure, when you look at AIF structure in GIFT, one and two is anyway pass through. So in that sense, quite neutral structure. When it comes to category three, it gives you much more clarity in terms of taxation, given that you are registered as a FPI. So it gives you a clear capital gain characterization versus when we look at a domestic structure, you have all these issues whether the income is taxed as maximum marginal rate or is it taxed at the capital gain tax rate. Is there a characterization of business income can apply or not? Because that worry anyway goes away because while FPI gives you a clarity of capital gain taxation, but even if the tax office was to say act, I wouldn't care, call nasty and say want to characterize a business income. In fact, they will end up taking zero tax because there's a on business income there's a ATLA exemption which is available. So it is not in their interest to recharacterize as a business income, and therefore they will be forced to give you a capital gain characterization. So that gives quite a clear path, and definitely there's a significant benefit for the manager, as we all noticed, where you get a 10% tax. The one point I wanted to just add was this whole MAT issue, where I think if you are an existing manager, probably in India, it probably makes more sense to set a branch or instead of a company or a LLP. The reason for that is that when you have tax holiday, there is a 9% MAT which is applicable on say a company or a LLP. But when it comes to branch, the MAT calculation happens at the entity level. So if your entity in India is otherwise profitable, you may be on an overall profit basis, maybe out of MAT. So that may give you an advantage of not even paying that MAT amount in case it is of the existing manager. Of course, that's not available in case of a new setup, being a manager setup in GIFT. Yeah. Yes.
No, I think thank you very much for exciting insight into the tax and also GST particularly and the MAT. So I think it really offers some good opportunities from tax perspective as well. And this planning would not perhaps even fall within the purview of GAR because they are intended benefits, tax benefits given. So if I'm not mistaken, when government is intended to give certain, if you are told that you invest in public provident fund and therefore the purpose of investing is to get tax benefit, but it is still excluded from the purview of GAR because it was well intended. That is how GAR works, and I think therefore again gift city will give you some kind of comfort being away from what is called GAR. But let me just now turn for a moment to the regulatory side, and can you tell us a little bit about the new unified regulatory authority that is being appointed? Because at one point of time you had to go from ministry to ministry and all this kind of stuff, and I think GIFT has also now come up with a regulatory authority where we are always concerned about getting how many clarifications, where do you run about. So I think Dipesh bhai, can you tell something? Yeah.
I think on the unified regulator, the government of India has already announced in the not this year's budget but the last budget that they will come up with the unified regulator. And this year's budget they re-emphasize that it will be put up on a fast track. In fact, the IFFC Unified Regulator Authority Bill was introduced in the Parliament on 12th of in the Rajya Sabha on 12th of February 2019, and it has been now further referred to the committee. And this year they have already said that they will put it on a fast track. I think what's important for us is that because in India our capital account is not fully convertible, you have this carve out situation right now that you have one zone declared as a international financial services center, and you have given all the transactions that you do in that zone in a dollar. You in fact you can't do a rupee transaction sitting in that zone. You can do all in foreign currency, and this nature of setup warrants a separate set of a regulatory regime because you can't work within the current framework which is more meant towards the domestic business, and here you are meant towards the whole sort of offshore business. And we studied the other models. We have seen Dubai DIFC model, we have seen Abu Dhabi, we have seen Malaysia, and various other models. And what was found was that at an appropriate time, all of this zone, they created the unified regulator, in fact, upfront before the businesses step in. And in India, I think the idea was that we should get started. instead of waiting for the unified to come in. And the unified will come in once the government feels they are 100% confident in terms of how the transactions are rolling, how the business is coming back to the zone as was envisaged. And there are now some success story emerging. So what we have seen is, in terms of banking, we have close to 13 banks now in GIFT, and they are able to do $22 billion transactions in last 3 years put together between them. And close to $2.5 billion of ECB has been lended from the GIFT City branch, which were otherwise being given from the overseas branches to the Indian corporates. So I think there are clearly the business scenarios which are emerging. Insurance also, we've seen business emerging of around $30 billion from this zone in dollar. And on capital market, we are seeing daily volume close to around $3.5 billion happening in the exchanges operating there. So with this success stories now and the businesses operating, it's the right time for the government to take a next step and get the unified regulator operationalized. And this government already in the budget said that it will be operationalized on a fast track mode, which is, I think, in a way help everyone, because you go to a one zone and you get all your issues clarified. And today, as you rightly said, we work with all the regulators, RBI, SEBI, IRDA, and to the Ministry of Revenue. And then you get a combined effect in terms of the businesses to have a clarity. But at one unified regulator will solve everyone's
I
problem.
think it's really helpful. I remember in the context of Mauritius when we were helping them set up offshore financial center. Very first thing was they would make a phone call and you get a reply in a day, 24 hours time, on any question. They set up what is called Mauritius Offshore Business Authorities Mauritius Business Offshore Activities Authority, MOBA. And Iqbal Rajawali was the very dynamic. But at one call, and within no time, you get very important clarifications, which you will be amazed that, and that's how Mauritius grew. Today, Mauritius' financial services sector contributes almost 12% to the economy, which was zero in early 1990s. I think so. I think learning from there, and now we are more learning from Dubai. We have done in Singapore, everywhere. Get some kind of authoritative, conclusive kind of advice, so that you're not confused. And I hope, really speaking, that very soon tax authorities will become part of this.
Yes.
I think this is a very important part, because often, and with a lot of respect, what happens, all the red carpet comes, but it's pulled under your feet because of tax issues that come up. I think we are getting a lot of issues because of that, but I hope someday it will happen as well, because you never give up hope. And that brings me one more question, Dipesh bhai. Any draft regulations for investment advisors, the portfolio managers, and anything in the works? If you could just tell us a little bit about
Yeah, I
it.
think, see, when the SEBI came out with the regulation in 2015, what we felt that the regulations were very enabling, which means that they allowed all sort of activities to come up, whether it was the exchanges, it was clearing corporation, it was the broking entities, and they also allowed the investment advisors, portfolio management services, and the mutual fund also as a part of the umbrella regulation of 2015. What happened was that after that there were quite a few instances that it was only the institutional business which was getting operationalized, because the central bank, Reserve Bank, wanted first the institutional category to be more functional, and then a retail can be considered. Recently, and probably this may not be in some circular or what, this is a clarification issued by the central bank, that now you have a non-resident individuals and foreign individuals, they are allowed to participate in the International Financial Services Center. No, I'm not talking of the Indian residents individuals that are still, they are not operationalized the LRS for the zone. But if you are a foreign individual or a non-resident individuals, you are allowed to use the GIFT platform to invest into the exchanges. And then came the requirement of the investment advisors, mutual funds, and all, because now there were retail participation visibility here. We have right now been working with the SEBI. We have submitted an draft operating guidelines as required by the regulator for the investment advisors. In fact, one applicant has already got a first stage license to operate as an investment advisor. He is waiting for the operating guidelines to come out. And the two other pieces, which is the portfolio management services and mutual fund, they are work in progress right now. We are discussing with the industry participants, taking their feedback from the law firms, and then we have been asked to submit a draft which they will consider at an appropriate time.
Excellent. And Rishabh, uh, just to come back on the SEZ regulations, one of the requirements in IFSC is what is called net foreign exchange positive. The unit has to be. Uh, can you throw a little light on that and how does it work? Especially in the context of fund. You know.
So just before that I answer, I just want to add to what Dipesh Bhai said
Sure.
on the investment advisory regulation, the PMS regulation. So those, of course, the draft and progress with SEBI. But once they are out, they will throw up a lot of opportunities and interesting structures. So, for example, we have this provision of 9A under the Income Tax Act where a domestic fund manager is allowed to manage offshore fund. So you could have a situation that you have a 9A from GIFT through a PMS license where you will be able to manage offshore fund and you will again not pay tax on that income because you are in GIFT. So structures like this will emerge. Also, the manage account situations that we have, you could look at again a PMS license for manage account where the significant tax saving
Thank
versus US. So those are the structures which will emerge. So coming to the NFE requirements, so unfortunately, I must say that given that the IFSC regulations are part of the SEZ law, and SEZ law came with the specific purpose of promoting exports of software industries and all that, right? So the intent was to promote exports. So therefore, there was a requirement which was put in the regulation to say that you should be a net foreign exchange earner from the government perspective, from the country perspective. But when you look at the IFSC and when you look at AIF funds in particular, the objective is completely different. Objective is to get onshoring what is currently done offshore. So when the objective is different, then you apply the same kind of guidelines or the rules, then becomes a challenge. Now, when we looked at the NFE regulation, the NFE formula, in essence, takes into only revenue items, which says you take your foreign exchange earning minus your foreign exchange expenditure, and that should be at least rupee dollar one positive. Now, in fund situation, what was happening is that when the money is coming from offshore investor, it's a capital flow, so it's not part of the formula. When you make an investment, again it's a capital flow, it's not a part of the formula. And when you earn capital gain, it is not part of the formula. So what was happening is that only the management fee, which was paid to the manager, is treated as a negative because it's a revenue expense. So we were facing this issue, but I think finally the Commerce Ministry, we had a lot of discussion with Commerce Ministry. They accepted the fact that given that the management fee is also paid out of the capital flows which are coming from the investor, or the money belonged to the investor, that will not take that as a part of the management fee calculation. So that's how they have accepted the fact that the fund would be the fund would meet the NFE criteria. In fact, there is a broader regulation change which is currently going on, and hopefully in next 1 or 2 months we will have a change in regulation itself, which will clarify the issue that the NFE is not an issue from a fund perspective. From a manager perspective, it's not an issue because manager is earning the revenue in terms of foreign currency, so it's always able to meet the NFE requirement. But from a fund perspective, we will have greater clarity in 1 or 2 months.
On a lighter note,
Yeah.
it's a very good provision that you must always make profit. Because you have to make profit. So India will guarantee that there will be profit from whatever investment you make. And when your convertible rupee, the rupee that you can convert into dollars, is basically even uh, contained in the concept of foreign exchange. Foreign exchange concept is different from foreign currency. Foreign currency like currency other than India. But foreign exchange could also entail Indian rupee that is convertible into dollars. So I think very good idea. I think this is a good provision, incentive for people to always make profit. If you don't make profit, you can't operate there.
But
Anyway.
there is, I think, currently, while this has been discussed and the Minister of Commerce is considering a regulatory change, but currently some mechanism has been worked out with the Development
Sure.
Commissioner for
Yeah.
approval,
And
which
they
means
given the unit.
they already allowed an unit approval of an AIF
After
fund.
making full disclosure, we are
Yeah.
not kind of hiding anything.
Right,
After
right.
making
And
full
they've given
disclosure.
the approval on the basis of that the fund gets this money from the investors is parked in the IFFC banking
Correct.
units, and he earns an interest out of the money that he is putting in. So that has been considered as an net foreign exchange positive and given a license for
No, I think I was just being on a lighter note that it's a good provision that you must make
That
profit.
requirement is over 5-year period to address this loss issue. So just to be
Anyway, but
defending the
that's a good
government to an
incentive,
extent.
good incentive. And that brings me to another. I think you made a point, Shabai, on you can have operations by a branch, or even if you have an entity there, is controlled by the same people. So these are all related party transactions that you will get into, and that's the most hot subject today in from regulatory as well as from tax perspective. But that brings me to another issue in relation to what you call transfer pricing arrangement. If you are operating here, now you begin to operate in Gift City, and some people are there, some people are here. How do you manage the transfer pricing regulation? So, Rajesh, can you just give some glimpse? And if you want to add something, feel free.
Sure. I think two things that we probably need to take note of, even while you're considering any kind of gift structure. What is presumably going to happen, and something that we see with every other fund, right? You already, especially who are existing funds, you already have a set of people who are in the domestic tariff area, right? Are probably involved in managing the other funds and all. And let's say you're doing a new fund launch from Gift AIF. Yes, you may put in some people on the rolls there, but there is still some activity which is going to happen from your existing team, whether in Bombay, whether in Bangalore. So what you need to keep in mind is that you're still, I think, two things. One, the intent around gift is because obviously if you're setting up a fund, you're setting up a management entity, you have to reflect that there are key persons. The KMP that you're expecting, you would expect them to be in gift also, right? And the second aspect around it is also that any arrangement which you are having with the entity in the domestic tariff area is going to be subject to transfer pricing. What you don't want to land up is probably a situation where the entity in gift is literally a shell entity. So you're going back to the same old, what's it called, debate or issues around a manager being set up in Mauritius, not really having any kind of decision making and all, and everything going into the sub advisory where people are still questioning whether what the transfer pricing arrangement would be. So yes, the transactions will be subject to transfer pricing, but at the same time, I think the intent is that there is enough scope or infrastructure to actually put in a proper team out there, so that even though yes there will be transactions between the onshore entity and the entity in gift, but you're still expecting or hoping that there is enough substance and enough people out there in gift, so that most of the profits would be attributed to the entity in gift, because otherwise you're going to end up back into the same old debate around where is the bulk of the profit supposed to rest.
Yeah, so just to add to what Rajesh said is that whenever we have this discussion about gift setup, there's always a question comes up that how many people are required, what is the substance required. So I always make a statement that please do create substance. Your economic activity is to meet the people on the ground. And secondly, I just wanted to add even a legal requirement. So if you look at, because you're taking an exemption under Section 80 LA, there is even legally there is a requirement for complying with transfer pricing. So even that legal requirement does exist. So therefore, please do look at these structures with the intent of creating substance. It is better to send somebody to Ahmedabad rather than sending somebody to Mauritius, yeah, or Singapore, which is much more costlier.
I always say tax presence is 45 minutes away.
Yeah,
Tax substance is 45 minutes away.
and probably we'll have bullet train as well.
Yeah, in 2 hours.
Yes. No, wonderful. I think. Thank you so much. But that brings me to discuss another subject, which is not really hot, but it's hottest, and that is about the surcharge on non-corporate entities, in particular the foreign portfolio investors and the Cat 3. I think
We should
willy-nilly. I think
before he starts, I think we should put some time limit, otherwise we'll go on for 2 hours.
I think in
I'm
India,
sorry.
what I find today, I think why do you see so much presence here?
I-
Because markets are not that great. So if you don't have much to do in the market, better come and listen to some people. So I think that may be one of the reasons why we get next time when markets are hot, you see how many people come and listen to us. Even otherwise they don't. But that's all in lighter vein. But thank you so much. So Richie, could you just talk a little bit about FPS surcharge
Sure.
and what's happening on that,
Yeah, see, I think like you introduced the topic, I think everyone has his own view on what happened, why it happened, and obviously the fallout is in front of everyone to look at. I think when this issue sort of came out, one defense that some of us in the fraternity, when we were talking to our clients, we were hearing was that is India trying to sort of shake off trust-based structures and look at more corporate format of participation, because there is always that KYC, lack of transparency attached to a trust format. Like who's the trustee, who are the beneficiaries, discretionary, determinate. Is there some layer of masking which is possible in a trust format, and hence should we encourage a more corporatized sort of format where India, SEBI, IOSCO platform, exchange of information. There's so many other avenues, and hence you can have a lot more sort of light around who the end beneficial owners are. Unfortunately, if that was the way that SEBI or the regulators wanted to go about, SEBI has changed the KYC norms that are applicable on FPIs back and forth on so many times. A possible solution could have been that okay, you changed yourself to a corporate format and so on and so forth. If you're not regulated by SEBI, so it would have taken the AIFs out, REIT and with everyone out, anything which is SEBI regulated. Or if you are a broad-based fund, you are coming in as an FPI or you are institutional fundraise. In those cases, again the UCITS and so on and so forth would have been out. And clearly, we are talking about those trusts which are private trusts set up for few individuals or family offices. There, the issue would have come up that okay, should we be nimble enough and sort of reorganize ourselves in a company format and so on and so forth. Having said that, because they have not sort of carved out what trust structures are they talking about or what non-corporate format they're looking at, and they're looking at everyone with the same yardstick, irrespective are you SEBI regulated either in India or you are regulated by appropriate regulator anywhere globally. Now to suddenly expect that okay, the solution shouldn't have been that okay, reorganize yourself. It should have been backed up by an economic rationale that okay, we are looking to sort of increase our tax revenue, but are the cash flows going to sort of tap away just because you have added that layer of uncertainty? And again, we are talking about FPIs who have been set up in a company or a non-corporate format. Now, within the same class of investors, you are looking at how they have been set up as a way to sort of divide the tax rate. So I think that's where the challenges have been. I think some structures are also being discussed that okay, if we are a domestic setup, could we have organized ourselves in a non-trust format? A company or an LP are the only two other options out there. Now, the Companies Act obviously does not lend itself to being used as a fund platform. Here again, we can examine the GIFT Companies Act because a lot of sections have been relaxed. A lot of the sections apply in a slightly modified way. So I think some exercise to figure out if a gift-based company could operate, because the pass-through or the rules of taxation for at least the FPI is already out there clear. The second aspect is could an LLP now be looked at more seriously? But again, given the amount of data available on a public platform, if you're set up in an LLP format, an LLP can lend itself more as an SPV as opposed to a pooling platform. But again, some of these analyses now will have to be more seriously looked at unless there is a recall or some clarification, which again cannot be ruled out because I think, Nishith Bhai, I think you've been part of some of the
yeah.
recommendations, not just to MOF but even to directly to PMO now. Can we have some attention on this issue?
Yeah, I think it has become a whole-time job, pro bono in many ways, to help the foreign portfolio companies because now they are not making money. So what can you do? But in lighter vein, again, on that, I'm saying that it is very strange coming from finance minister and from chairman of Central Board of Direct Taxes to tell you the scheme to avoid their own tax, which is strange, right?
And not even giving clarity on gas.
And there is no clarity on GAR, right? So I think it is little, it was unintended, but some of the other positions have been taken, and therefore I think the whole problem is going on. Lot of most of people may not know that most of the FPIs overseas are also constrained by regulatory factors there, because like Massachusetts business trust, it has to be in business trust form, not in necessarily what you call or UCITS and stuff like that. And so a lot of loss has happened, and who is really, they think that this is the tax on the rich, that is how it has been classified, but poorest people are deemed rich in our country, because most of the investors in mutual funds, foreign mutual funds or other ones, they are all who? Small people, pension plans, who are behind that. So effectively what happens, the direct tax is not on imposed on them, but the FPI itself is taxed. So net of tax return goes, and that is what creates a lot of hassle. 99% of the countries in the world do not tax foreign portfolio investment by capital gains or otherwise, which is, and India is taxing. It increased tax from 2000, I think 13 14 onwards, something more. This time it was really a bombshell. So unfortunately, this situation we are in, I'm sure, with this experience that we are confronting at this point in time, we'll learn some lessons. But I don't want to go into detail. As you said, it can take 2 or more hours, at least 2 hours minimum. But we'll discuss that on a separate occasion. But let me very quickly, if you can, we are coming to an end of our session. We'll take some questions after that. But at least for the time being, Dipesh, can you tell what do you see in the next 3 months, or 6 months, 1 year, 3 years, or whatever? Some kind of roadmap. How do you see things unfolding? If you have some thoughts, if we can take a couple of minutes, and then we can close this session, and then we start with the question and answer.
I think the type of the re-emphasis the current union budget has provided for the International Financial Services Center, looking that in mind, in next 6 months, we can definitely see a lot of structures on the alternate investment funds emerging. Along with that, as Shar was rightly pointing out, this PMS and the investment advisory structures are been knocking the doors to step into the zone and start operating the other business verticals also. So we see clearly the capital market running into the lot of new structures and businesses in the zone in next 3 months. But parallelly, we are seeing a lot of interest of foreign banks coming in. We got the Standard Chartered Bank licensed for the Gift City branch, and the other foreign banks are in process, and some of them have already applied to the central bank. So clearly, the foreign banks are also seeing as an opportunity to step in. And the insurance entities, the recent budget has identified, brought down the net own funds requirement from the International Financial Center from 5,000 crore to 1,000 crore, which means you have a cross-border insurers can actually be better off inside the international zone because he has a order of preference. Instead of doing it from outside, he gets a business first. Is if he is in the SEZ zone in the gift city. So that in 3 months we see a lot of the structures and businesses emerging. But clearly, from 1 year to 3 years perspective from now we see currently we are at 200 companies with 9,000 people operating. We can easily cross around 400 entities in that zone, and we are looking at a number of around close to 15 to 20,000 jobs in that zone. So we have one large foreign bank coming in with 1,500 employees in the zone for doing the global delivery center. So we are seeing tremendous growth in terms of businesses coming in, as we have both special economic zone and the international zone both operating together in that zone.
Thank you so much. So I think, as you can see, in a way, if I conclude that in the midst of all the chaos we have, tax chaos or regulatory chaos, I think we are getting some island of excellence in Gift City, and there is a lot of light around that space at this point in time. It's a real gift at the right time, and we are very happy that it's progressing well, and I hope it will continue to progress. And with that, I would like to close this first part of the session, get on to the questions, answers. So I'm sure you have a lot of people, but those people are on the phone. I think let us give them preference because you can't walk away very easily. At least they can quietly switch off. So please, those who are on the phone, please go ahead with your questions. We'll be delighted to respond. Thank you.
Participants on the audio call, if you have any questions, please press star and 1 at this time. Participants on the audio call, if you have any questions, please press star and 1.
I think we are so clear. Thank you very much. So that there are no questions left, look like, right? And let's then have questions from people here in this room. So, most welcome. Please tell your name and ask a question. Be very brief, so it's not becoming a speech.
This is
Thank you.
Chirag from Alchemy Capital. My question is to Chirag. So this is about AIF Cat 3 in GIFT City. So because they are entitled as an FPI investment for cap gains, the question is it possible for them to give up this entitlement and claim all the gains as business and then claim the tax holiday? If the answer to that question is yes, then after 10 years, is it possible to switch back to capital gains?
Unfortunately, the answer to your first question is no. So probably the second one will not arise. But the reason for it is when you set up a AIF3 and you want to invest in public market, the regulation clearly say that you will register yourself as a FPI. Now, once you register yourself as a FPI, the Income Tax Act is very clear that earlier there used to be a lot of even in context of MPI, I know he did a AR ruling before the law was amended, where he actually got ruling from authority that the nature of income of the FPI is business income, and therefore without from a US FPI, I remember. I don't know name Fidelity. Yeah, it's that market credit. So we can talk about that. There is no P or Fidelity in India, and the nature of income is business income, so Fidelity should not pay any tax in India. So, unfortunately, the law has thereafter been amended to give clarity in Section 2 to say that any investment by FPI would always be in the nature of capital asset, and therefore the income arising from that capital asset would always be capital gain. So, it's not a matter of choice that you can say now I don't want to treat it as a capital asset, I don't want to apply the Income Tax Act, and I will treat it as a business income, unfortunately. So,
Otherwise, everybody would have taken a derivative route and gone at 9%.
that is correct. Not even 9%. Yeah, I mean, you could probably pay 9%.
I mean,
at
the
most,
headline
yeah.
rate.
Actually, there was a conflict between domestic funds and the foreign funds. So when foreign funds used to be there, mutual funds and Fidelity, another one. So for a long time they are claiming capital gains, and when I looked at the accounts, I said, but you keep on selling and buying. This is actually your whole time business activity. If it is business profit, in absence of permanent establishment, there should not be tax. So, Advanced Ruling Authority said, yeah, it is a business income, no tax. So that was first Fidelity 7. And then we applied for 39 other rulings, and suddenly it happened. There's a billions of dollars question. What's happening? In fact, CBDT, you will remember, I think, that they issued even a draft circular to say that all the foreign funds, their income will be considered business income. But then the Advanced Ruling Authority, second other ruling that came, it said no, it should be capital gain because they saw the numbers were pretty large, possibly.
This is because in the US tax code there is section 425 which allows you to be elected as a trader.
Right.
So that provision is not there in our tax rules.
Yeah, and because there is subchapter M and all those kind of things.
Exactly.
But the whole thing is that's how this whole thing got changed, and then they brought a statutory amendment to say that all the income of FPI would be deemed to be, or at least the capital gain. I think on as far as the derivatives are concerned, it's still different.
No,
it's still not the capital gain.
At
one point of time,
even derivatives capital.
So derivatives
anyway.
So which is the anomaly, right?
I always forget what I argued because otherwise you can't be innovative next time. So and then once it is done, it's precedent. So please don't ask me too many questions. Okay, if they are difficult questions, they will answer. But I think it's very interesting syndrome. What has happened in our income tax is everything has become fictional. So it's a story writing. Majority of provisions are not common sense. So that is why difficulty arises. That everything is fiction. This will be deemed to be so and so, and this will be deemed to be so and so, and this will be deemed to be so and so. And that's why the conceptual problems keep on coming. And domestic people were happier calling capital gain because lower tax. But foreign people were happier having business income because no tax and stuff like that.
In the domestic context, the tax authorities used to say it is business
income. It is business income, exactly. So I think, anyway, so I think that was the background. I'm sure that you are all familiar with that. So it's just a little.
One small point that the test of that is actually the velocity of trading. That should have determined which way it should have gone.
There are several factors.
This is what the Central Board of Direct Taxes has a circular which puts on all those tests based on all the jurisprudence which is available in the circular.
So in fact, the first case, right, and which all of us used to rely on was Hope Larsen, the promoter of Larsen.
Correct.
Yes, whatever, 40, 50 years back, right? Which actually set out what the tests are. and which is what all of us kept relying upon to say, how do you make that determination, right, on facts and circumstances.
So again, to the page guy, if the AIF Cat3 has to become a hit in GIFT, either the FNO volume, even for individual securities, needs to be substantial there, or else the tax on the onshore FNO trades, if FPIs are allowed. I hear that there is some anomaly and proposed to be resolved. But if they are allowed, then the tax treatment needs to be at parity with our current structure, which is in Mauritius. So currently, we are not paying any tax in Mauritius. If we were to shift here, again, we need parity to shift.
I think that's a very valid point in terms of investing into India from that zone. If you don't have a parity with what is happening from other financial centers, then obviously you will look for different structure. But as far as the Indian the volumes on the exchanges are concerned, I think the volume have been increasing on the Indian stock futures. Obviously, now with this AIF and all coming in, you will see more volumes emerging in that zone, and it will help people to participate. Larger participation would bring in larger volume. That's what we believe now.
Tax parity, of course, is a work in progress.
Yeah.
It's a work in progress.
So
with the
eventually, I think that's what everybody wants, right? As in, from a comparison standpoint, that's effectively what you look at.
So there are two changes we're talking about. One, allowing them to invest in FNO in India, and B, making it at par with the tax rate in Singapore, Mauritius. Because even if you're treated as capital gains, the
No,
rate is.
I think the simple thing is to say that don't look at it as a FPI, really. Just look at it as a classical trading entity, in which case everything is business income. And business income taxation continues.
But then you have the FPI restriction, right?
Yeah, that's what I'm saying, right? So obviously it's tough for the government also at a single shot to say that, okay, we are not going to tax you in entirety, right? It takes time. It takes a lot of
In fact,
meetings.
this proposal was there as a part of proposition that we made in before the budget. Unfortunately, that was the only proposal which was they said we'll keep it aside for the time being. Everything else was actually given. Yeah, you see all the amendments. Yeah, including the 10-year tax holiday for that.
From CFRs. So, want to just cover migration of existing fund and of course the LP's consideration because of course it is not very much beneficial for LP. So I don't know if you can say that the poem risk is minimized, if at all. So would the LP's consent if we actually migrate a existing for one?
So I think I can say from a LP GP Council perspective that we are currently in midst of planning one or two migrations, but there frankly we are yet to test the LP appetite on the shift, because if the rationale which we can throw is only on tax efficiencies for the manager, then the challenge is somewhat stiffer. Then let's say that the original issues we faced when we migrated from a complete Mauritius structure to a master feeder structure, when we said that if you unify the structure and invest through an onshore AIF, there are a lot more investment opportunities that will open up. So there we could migrate a lot of structures which were classical Mauritius investing into India to a master feeder. Whereas here there obviously are challenges, and also the challenge increases if let's say you have drawn down commitments, made some investments, then how you roll over to the, are you continue with your investments already made? Are you going to migrate? How will the carry be calculated? I think a lot also depends here on the caliber of the GP. See, if you're talking about a GP with a lot of track record and lot of their how they carry out their operations, the ODD, I'm sure as a manager you face operational due diligences. I think that can give a lot of confidence to the LP community, and again depends on what LPs also you're dealing with. A retail audience may not have too many ways to express their content or discontent, whereas an institutional LP raise will have their own asks that what exactly are we dealing with. So there is a first mover disadvantage to begin with. Let's have a lot of structures go live first, then think of migrations. Migrations is usually something where you have already proven that this structure works. Then if you migrate, it's a lot easier conversation. Then say something where you are also moving, the track record is something that you have to sort of demonstrate. Your LPs sort of lose patience. So, and again, who your LPs are. So it's a mishmash of lot many things without even getting into the technicals of how you migrate. A more easier example of how we have seen structures migrate has been a lot of Cayman structures are planning to now migrate to Singapore, the SWAC, Variable Capital Company. I don't know if you're aware that a lot of fund managers who have been based out of Singapore yet managed funds out of Mauritius or Cayman, because Singapore-based funds have their own challenges under 13R, 13X, and so on and so forth. So now with a variable capital company where you can redeem shares based on issuance and so on and so forth, I think that will throw us some real live examples of migrations. I think that's my feedback.
Singapore variable company not operating.
Yeah, it will be
No, it
operational
will
by
be
end of
operational,
the
which
end of
is
the
where
year.
the Cayman is going to migrate into.
Yeah, end of the year.
But Richie, just to add to your question, I have seen and been part of one migration from Singapore to Cayman. Both were relatively, I mean, Cayman is zero tax, but even their re-domiciliation was not easy because you have to convince the investors, you have to, and finally the solution was close down the Singapore fund, open up a new fund.
It's
No, no,
difficult
yeah.
conversation.
Yeah,
It's a
yeah,
difficult
very
conversation. But having said that, the arithmetic of just moving from domestic to GIFT itself, in my opinion, adds to a 0.25% increase in the return simply because of the absence of GST.
So, see, I think the return and the tax is unfortunately or fortunately a secondary conversation point, again, depending on who your LPs are. So, it's a
Yeah.
little LP
You
comfort
got to have
driven.
support of your LPs.
Yeah, absolutely.
Very important. But in that case, we had to actually shut down the Singapore entity to open up the Cayman entity.
Sure.
Because again, in Singapore, the law is slightly antiquated in the sense that it cannot merge with the foreign company not merging and all the thing. Whereas what we call migration of this, or sometimes it's called export of companies, is easier, like in Delaware or Mauritius, stuff like that, or Cayman. And therefore, the
yeah.
corporate law issues equally important, and
In-
whether it
yeah.
tantamounts to liquidation, then another question comes up. So I think those are some of the things.
I think in fact the SWAC rules in Singapore actually have a dedicated section on allowing inbound migrations of overseas structures. So they have actually planned.
It's part of the marketing deal.
Absolutely.
Sorry, just taking that a step further, my name is Pradyum, I'm from Triton, we manage a category 2 AIF. So, migration aside, setting up a new AIF within GIFT City, how would you position that to LPs, and what are the benefits, if any, let's say, setting up from a LP standpoint, Mauritius versus GIFT City, how would they look at it? Typically LPs based in the US.
So just to add to that question, I have a question which is comparative, if I can. So my name is Manoj, I work for Banyan Resources. We build and manage soft and social infrastructure in India. We have been facing challenges with respect to the hedging cost of foreign currency in India. When we transfer that money into the Indian currency, there is a charge of the reducing value of the rupee as compared to the dollar. So that cost invariably sometimes 6%, 7% over and above sitting on the 4%, 5% that the money is coming in, which is equivalent to about 11, 12%, which is the borrowing cost in Indian in domestic currency. So how is it that GIFT is going to kind of help us in this situation where the transmission is direct and there is no this hedging cost which is coming to us on our PNL, which is the additional cost of our weighted average cost of capital to infuse in the projects that we are working.
I can take the first question, which I think is slightly different from the second one. The first one is, I think any of the situations we are looking at currently does not involve LPs coming directly into a GIFT format to begin with. We are still looking at a feeder being set out of Singapore or Mauritius or any of the other jurisdictions because of the tax returns that you have to file. I think there is still some work in the pipelines where can we sort of pay the full tax at the GIFT level, and accordingly can the investors not be made to file tax returns. The solution is still in the works.
That probably there's, because there's already a withholding tax provision, right, under AIF2 situation, where the pitch is that once the tax is withheld, there should not be a requirement to file return. So that hopefully in next 1 month we should have that notification out, hopefully. So that will give a solution to that.
So till that happens, clearly we have a lot of LPs who have aversion to filing tax returns, and B, I think a lot of them are comfortable with the governing laws of a Singapore or a Mauritius, because how your contracts are enforced, what would be the recourse, what is the position taken by the regulator, and so on and so forth. The entire LPGP negotiation is sort of crystallized in the feeder where the LP is landing.
Yeah.
So today that comfort is out there with certain
Exactly.
Cayman or a Singapore jurisdiction.
Yeah.
Mauritius also, by the way, took a transition. Till 5 years back, we had to explain why Mauritius. So the DFIs or institutional LPs would have aversion to Mauritius also at that moment.
Right.
But then eventually that confidence came. So I think even though GIFT is part of onshore AIF, yet I still feel that for us to deliver that perception of stability of law and how your contracts would be bound, because these are illiquid platforms we're talking
Yes.
about, 8-year, 10-year platforms. So I think there is still a gap between GIFT itself being pitched as a feeder vehicle.
So while we are talking about tax, because we are all tax lawyers and accountants, we are all tax obsessed. Before our conversation started, we started tax, but often we forget there are larger issues. And one of the most important issue, and the point that I argued in the case of Blackstone, was in relation to bilateral investment protection treaty, which is a different treaty than the tax treaty. And it actually protects you from the adverse changes at times in the law or regulation or judicial system, or something that goes adverse. Suppose there's a new regime, a gift, correct? So it's evolving still. So there could be ambiguities or there could be some changes in the law and stuff like that. Now, when you have investments coming from countries like Mauritius or Singapore, Mauritius is by far the best negotiated bilateral investment protection treaties called BIPA, or sometimes it's called BIT, stuff like that. And some of you already heard, even in case of Vodafone, the cases there in system. There are about 25 cases against India on the BITs. They've all gone in arbitration. So, access to justice was the first part, first phase in which this happened. Australian company won arbitration case against Coal India, and they could not enforce it for 9 years, I believe. And therefore, it was kind of a violation of Indian government not providing access to justice. And, based on that, the arbitration happened and it went against India. And, so some compensation is paid and stuff like that. So BITs also bring a lot of comfort to the investors, and the way in which we look at as a fund manager, you're a fiduciary. Your responsibility goes to your investors, and your investors include not only billions of dollars pension plans, but small person behind that. So why FPIs withdraw money at times when something goes wrong? Because they can't risk the small person's investment at a risk. If they feel this is not going to be resolved very soon, in long term India is great, but they feel that okay, in the short term let us cut loss and invest in other geographies, because their Indian allocation is 1% or 2%, and therefore they try to not spend too much time. But BIT is a very important instrument in international financial world, and that is another justification which is non-tax justification. So it also justifies that GAR should not be applied when you set up a structure in. So this has actually been a reported case now, Blackstone, and so I think this is another justification you give why you need two-tier structure, because I think GIFT is an excellent thing, but it's a new baby. So you have to
give it some time
to evolve, and I think in the process, both countries win. Countries win, of course, taxpayers too, perhaps. But so Mauritius gave this out the whole.
There's an international arbitration
I was
center.
just about
Yeah,
to
even
say that
here.
one of the contract enforcement, what you were saying, that issue came up, and luckily we had Nishith Bhai as an mentor to solve this puzzle. What we did was, with the Singapore International Arbitration Center, now we have an agreement and they have an office here. So all the units and all the entities setting up in GIFT is able to adopt the Singapore International Arbitration clauses in their contract, and any disputes and related things can be heard, can be settled, and the award can be passed in GIFT itself. So that's something which has
In
really
accordance
helped.
with the rules of SIC, Singapore. So your entire process, only thing is when when you is in, so you sit there
But the
without
seat
going.
is SIC only.
It will be
Seat
still
is
the
Singapore.
SIC. Correct.
And the cost is also much less, I believe. Or is it the same?
It should be normally.
Compared to
Yeah.
Indian senior counsel fees,
Yeah.
it's not much.
But adding to what Richie
Yeah,
said,
exactly. I think
Yeah.
we are all very inexpensive
At least the
lawyers.
flight
you know.
ticket to Ahmedabad are cheaper than
Yeah,
Singapore.
definitely what no. But adding to what Richie said, there is a provision of SNAP in the regulations itself, although it has not been fully utilized. The SNAP allows investors not to be directly hit by tax returns and giving information as long as you have the UBO, but there is a slight tweak that is needed for that. At the moment, I believe it's favorable only for Cat 3 funds. But if that can be extended, then this problem can be sorted out. But in any case, Tushar, if what you're saying is no need to file income tax returns anymore, then I think this problem is obviated.
Yeah, please. Can you be a little louder in your name and organize?
Vaishali from Beacon Trustee.
All right.
In India, if we see the ratio of AIF set up as trust versus as LLPs, will that scenario change if we see the current amendments and provisions with respect to tax when we talk about AIFs in New City?
See, I think my sense, again, from a legal perspective, obviously from a tax perspective, you can have other views. We have traditionally favored trust for a variety of reasons. All the reasons that I spoke about, that how you can literally write your own code of governance, where we can sort of translate a lot of negotiations in. Now, in case you're doing an institutional raise, a lot of our fund manager clients tend to have institutional investors. There, for us to deliver that comfort that whatever you want to agree, in a truest sense, like had the fund been set up in a Cayman or anywhere else, for us to sort of replicate the entire log in an Indian context, a trust works wonderfully well. It is tried and tested, so many judicial precedents, everything out there. The format also replicates the LPGP construct in a best possible way. So there are so many non-tax reasons why trusts have traditionally been favored. In fact, I would also like to add that mutual funds, mandatorily by law, are required to be set up in a trust format. A same pass-through could have been given to mutual funds also if they were set up in a company or LP format. Yet, SEBI, in its wisdom, whenever the regulations were being designed, thought that the trust is the only format in which you can go ahead. The same was the case with venture capital funds also. So, traditionally, our laws have been just like Singapore, were very much corporate law driven. Like it was designed for companies and corporates who are more operative entities. Whereas a trust, because of the lack of preciseness in the law, and allows you to write your own pen on whatever you want to have as a code, was a very natural choice to look at from a fund perspective. So these are my non-tax. And again, from a tax perspective, like you said, LLP versus trust. I think there's so many.
Only the tax reason would be the new surcharge does not
Yeah.
apply on LLP
Correct.
versus the
That
trust.
may cause the shift.
Yeah.
In fact, I remember setting up very first private equity fund for AIG and ILNFS, and the choice was whether trust or a company. And one of the important thing was that in a company setting, if you make a loss, how do you return capital to the investor? Because you can return capital only out of the profits or the reserves. And so we had very antiquated corporate law, and there are many other provisions like that. And if you put $100 million, you got 99 million back. You're sitting on cash, but you can't return.
Yeah.
So some of those things, and I always love trust because you can write your own law. It can be better than your corporate law because you want to be governed with the LPs. You want to, that is your prime position, that you have good governance standards, but that could be even higher than what's provided in the Company Act. Anyways, somebody had a question. Right? Yeah, please, your name and.
Neeraj from Vista. I have a small question. Like, there are a lot of funds which are algorithm driven, category 3 AIs. So if it's housed in a gift city where the algorithm and the server is lying, now I don't know honestly what all laws may be applicable, but will it be a trade fired from India or will it be a trade fired from offshore? Because I think a lot of tax implications would depend upon the fact whether where the trade has been filed from. And the reason why I'm going to ask the question is when you look at these particular funds, it's not about the fact that how many people are sitting there, but it's about the fact that the server is there and the algorithm is sitting in that server from where the trades are being filed. And the reason why there is no unified scenario today. So when I'm looking at a gift city, there is an income tax implication, there is a SEBI thing, there is a FEMA thing. Right? So when all the things are speaking, and for some it is offshore, for some it is onshore. in this kind of a scenario, the trade which is being fired from a gift city, will it be offshore or onshore?
Yeah, currently the way the exchanges are operating in GIFT City.
So it's an exchange in India.
Yeah, yeah. So I'm coming to it. So currently, if someone is trading on an IFFC exchange in GIFT City, the broker who does the transaction, the servers are within the IFFC zone itself. So there's no tax implication because this settled there only. Now, when you do trade on the NSE and BSE in India as an AIF, obviously you are going to trade on the onshore. But there, right now, there is no tax exemptions. You pay tax if you do on a trade in the BSE NSE. As far
That's
as
correct.
See,
And
your
the
start.
good part is that irrespective of where the server is, and of course the server will have to be in GIFT because you're a GIFT entity. There is a because you're a FPI, there is a clarity of taxation, right? Because and you're talking about cash trade, right? So,
Yes. So
yeah. So basically, therefore, the nature of income is capital gain, and most treaties don't give you any tax benefit anyway. So there is anyway a domestic tax which is payable at 10% for a long term or a short term at 15%. And that issue, which if you were to have a server here, and in terms of permanent establishment and all, is not there because anyway you're paying tax as capital gain at the domestic tax rates. So that issue does not arise.
So I'm looking at it from a perspective that from a fact that this gift city entity would want to treat its fund as an FPI, will there be any challenges from an IT perspective?
No, so IT, as I said, IT you are resident, so you pay tax as per the domestic law anyway. And for FEMA purposes, you're non-resident. So for repatriability perspective, you will repatriate the money like any other FPI does into gift and then onwards to your investors.
See, your tax status is that of a FPI, right? For taxation, right? So merely because I'm trading on, I'm still taxed. We are not saying that you're not taxed, right? You're still being taxed. It's just that, just like we have quite a few special provisions for taxation of specific categories, you're going under the special provisions for taxation of a FPI income, right? So to that extent, it wouldn't really matter, right? Because as a foreign FPI, what, on algo trading and all or co-location, the biggest issue that used to come in was whether there is a PE or no PE. That was the really the issue that was there. That doesn't really come in here because I'm still FPI. My status may be that of a FPI, but I still don't have a PE related issue because I'm still taxing it as a FPI tax in respect of the gift unit in gift. So, which is why I would tend to think that you're not worse off for sure.
So I think if you don't mind, we can close at this point in time. We can always go on, but this I think half an hour we have spent. I hope this has been useful, and we really and sincerely thank you so much for taking to this webinar. Please keep on coming, and all of us are always there to help you whatever we can. Thank you so much. Thank you.